So, people want to know what happens at these risk protection hearings. They're kind of a new thing. I've defended these hearings before, so I'm going to tell you what happens. First, let's get into a little background, right? A risk protection order is filed against a citizen by a police department. The police are asking a judge to let them take your guns and ammo away from you for up to a year because the police think you are somehow a danger to yourself or others. It's that sort of thing that gets this whole case going and why you eventually may have to call somebody like me, and I hope you don't, but it happens. This formal risk protection hearing must be held within 14 days of the police actually taking your guns and ammo. And at that hearing that's 14 days after the taking, the judge is going to ask the sheriff's office to begin the hearing by presenting their evidence. What do they got on you that makes them think that you're a danger to yourself or others? Remember, it is the police department that brought the lawsuit against you. It is their burden to prove that you're a danger. And law enforcement will start the hearing. They'll be represented by their own attorney. This attorney is going to call their first witness. The judge will say, call your first witness, sheriff's office. They'll call the officer that drafted the risk protection order to take your stuff. I'm telling you, a lot of times this officer really doesn't have much to say because usually they don't know anything firsthand. They didn't witness you being a danger. Don't let this officer testify about stuff he heard from your wife or your girlfriend or you told a coworker. That's hearsay. Shut that officer down. Go on to the next witness who has actual evidence. Sometimes they will. They'll call the coworker or your dear friend or your wife, and they heard you say some stupid stuff about hurting somebody or hurting yourself. And that's the kind of testimony they're going to need to keep your guns for up to a year. But even if that's what their testimony is, it doesn't mean that they win the case. Because once the sheriff's office attorney has no more witnesses to call, they're out of evidence, and it's usually just the police officer that wrote the order, and it's usually one or two people that heard you say some stupid stuff. The hearing doesn't stop. We get our chance to present evidence. And I like to call my clients sometimes on this sort of thing. I wouldn't do it every time, but your client can clear the air on the situation, right? First of all, your client can explain what was said was taken out of context, right? It really was said at a bad moment, taken out of context. But more importantly, we like to accept a little responsibility for going through a rough patch in life, but that we've taken immediate action to remedy the situation. We went and we got therapy. We went to an old doctor and adjusted some medications. We did some life changes within these last 14 days that will show the court that we're not a danger to ourselves or others at this point, and we can have our guns safely. And that puts the court at ease that you're no longer an immediate risk, and the sheriff loses the hearing. This hearing lasts about 30 minutes, sometimes less, sometimes a little more. So if you're going through something like this in Orange, Seminole, or Osceola County, please give my office a call. That's where we handle these sorts of things, and let's see if we can help you out. I thank you for watching, and take care.